Okay, we can start. Good morning, everyone. Welcome to this webinar from Filip, Kowalczyk and me from Polish law firm Wozniak Legal.
Good morning.
The topic for today is the choice between employees and contractors in Poland, how to hire people without establishing a local subsidiary. I will give you first some practical information. We intend to go on for approximately 45 minutes. It is possible to send us questions during the webinar just by clicking the question mark button. We will select the most interesting questions, and we will try to give answers at the end of this webinar during the Q&A session. If you think of any questions later, you can send us an email, or you can simply give us a call. We are happy to help. Before we start, let me give you some information about ourselves. My name is Grzegorz Wozniak. I am a Polish lawyer. I used to work for many years for Allen & Overy in Warsaw before setting up my own company, Wozniak Legal. My area is corporate and M&A and cross-border cooperation. This is why we also deal with issues like employment, cross-border employment, and solving cross-border issues in hiring people. My colleague Filip Kowalczyk is partner at Wozniak Legal. He is also a commercial lawyer. He specializes in dispute resolution and employment law. I think it's worth mentioning here that Filip was also trained as a judge, which gives him additional perspective. He is able to look at the cases through from the judge's perspective, which is always very helpful. Just 2 words about our company. We are Wozniak Legal. The company was established. The firm was established in 2007. We are based in Warsaw, but operate throughout the whole country. We have 20 employees. So by the medium standards, by the Polish standards, we are the medium-sized law firm. We specialize in corporate, commercial, and private client matters. We cooperate closely with accountants, tax offices, and other law firms in Poland and outside of Poland. We are also part of the New Circle, which is a unique network of ex-Allen & Overy lawyers throughout Europe. We are covering major jurisdictions in Europe, and we focus the network. New Circle focuses mainly on corporate and M&A areas. Now, going further to our topic is, as I mentioned, is a choice between hiring employees and contractors in Poland without establishing a local subsidiary. Many foreign companies are looking to hire in Poland due to the rise of remote work, digital transformation, and the need for skilled IT talent. As you probably know, Poland is very rich in IT personnel. Polish IT specialists work all over the world, but many of them are returning especially from the UK or from the US to Poland and prefer to work from home. Poland, just maybe before I jump into the subject of the labor law, Poland is one of the most popular business locations in Europe. There are at least 3 factors which are responsible here: central location, attractive labor market, and facilities for foreign investors. These are just some of the benefits of starting up a business in Poland or hiring a new personnel in Poland. So far, there has been always a system where the easiest solution was to establish a legal entity in Poland, and a lot of US and UK companies open businesses in Poland by opening a local subsidiary and hiring people by this subsidiary. This is governed by Polish labor law, and there are established rules. And our webinar is not about this. What is the recent phenomenon is that foreign companies are trying to hire people without establishing a local subsidiary. Why is it complicated? It may, for the first glance, it may look like a very easy option, and many companies think that this can be somehow regulated by the agreement. And the answer is not. This is not so easy. This causes many complications, and the subject of this webinar has been created on the basis of our experience. And I must say we are one of the very few experts in this field in Poland about cross-border employment. If just to give you a short explanation before we go into the subject and explain you how to hire people in Poland without establishing a local subsidiary. If a UK company hires a person in Poland, the company is automatically regarded under Polish law as an employer and must comply with Polish employment legislation. Polish authorities, and this is important to remember and to be aware, that Polish authorities and Polish courts are likely to consider a foreign company as an employer regardless of what is stated in the contract. Very often we had cases where the parties to the employment agreement are free under Polish law, and under English law, parties are free to choose the governing law of the contract as they want. So very often English law is chosen as a governing law. But even if the foreign law, if the English law is chosen as a governing law of the contract, UK company, if they are the employing party, automatically assume the status of the employer and is obliged to follow key obligations on the Polish mandatory labor law. So, to put it bluntly, if you want to employ a person in Poland, person residing in Poland, and if you are a foreign company, it has to be handled by local lawyers, by Polish lawyers, helping you to go through the whole procedure. So this is an introduction, and this is a short agenda of what we will be talking about during this webinar. This is why this classification, whether this is an employment contract or B2B contract, is so important. In Poland, the distinction between employees and contractors is crucial for tax benefits, legal protection, and compliance. This is, as we will try to explain during this webinar, this is a completely different regulation for employees, which is governed by labor law, and for independent contractor, which is governed by civil law. These are the key considerations. How to distinguish labor law contract from civil law contract. And sometimes, of course, the truth is that nothing in life is ever so simple and black and white. So there will be many cases where it's very hard to draw a line whether this is really a employment arrangement or civil law independent arrangement. But these are the key criteria. So subordination. The first bullet point is subordination. Employees are subordinate to the employer, which means to the person who supervises their work. They report to someone, and they have to follow instruction of the supervisor. This supervisor controls how, when, and where the work is being done. So the key obligation of the employee is to follow instructions of his superiors. while contractors operate independently and they can determine their own work methods and schedules. Second point is remuneration. Remuneration, employees are guaranteed minimum wage. This is a general rule that employment agreements are regulated. There is a labor code. There are many rules which specifically regulate the relationship between employee and employer. While contractors generally negotiate their compensation freely, and there are no rules in this respect. The third point is social security and benefits. Employers, and this is so important if we have a case which I mentioned earlier, UK employer who wants to hire a person residing in Poland. If a UK company becomes automatically an employer under the Polish law, employers must register employees with ZUS. ZUS is the Polish Social Insurance Office for pension, healthcare, and other social security benefits. On the other side, contractors are responsible for arranging and financing their own insurance and benefits. So when the company deals with the B2B, we call it B2B contractor. B2B contractor, so the self-employed person pays all social insurance premiums by himself. The company receives just an invoice which needs to be paid. And the fourth point is risk and liability. Employees are protected from work-related risk by the employer, while contractors generally bear their own business risk and liability for their work. Again, there's a B2B contractor agreement with a B2B contractor is that it's an independent company which simply issues an invoice which needs to be paid for the work which was outsourced. So these are the four considerations. Now, so what should be done if we want to employ a person?
There are four types of contracts. The first one is employment contract, in Polish umowa o pracę. The second one is mandate contract, in Polish umowa zlecenie. The third one is contract for specific work, in Polish umowa o dzieło. And the last one is B2B contract. The first one, employment contract, is the most protective form of work agreement, and this is the only contract which is regulated by the Polish Labor Code. That contract creates a formal employer-employee relationship. The employee works under the employer's direction regarding how, when, and where tasks are performed. This type of contract provides full labor rights and protections, including fixed working hours, paid holidays, sick leave, maternity or paternity benefits, health insurance, and pension contributions. The employer is responsible for social security contributions, and the employee is protected against unlawful dismissal. The second one is a mandate contract. This is a civil law agreement regulated by the Polish Civil Code and is used for performing services or tasks over time rather than delivering a finished product. The contractor generally controls their work schedule, but can have some obligations to follow instructions. Social security contributions may also apply in this type of contract, especially if the contractor has no other source of insurance. This type of contract does not guarantee benefits such as paid leave or job security, and working time is generally more flexible than under an employment contract. The third one is a contract for specific work, umowa o dzieło. This is also a civil law agreement regulated by the Polish Civil Code. but this type of contract is aimed at delivering a clearly defined result, work or finished product. It is used mainly for creative or project-based work, like IT specialists. Unlike an employment contract, it does not create an ongoing relationship or impose obligations like working hours. The contractor independently performs the agreed work and chooses how to do it, and the contractor bears the liability and business risks of the task. This type of contract offers also no social security coverage, except in rare cases, and of course, no labor law protections. And the last one is B2B contract. This is a commercial contract between two businesses, often used when an individual operates as a sole proprietor, self-employed. The contractor is fully independent, organizing work without any control, so the contractor bears all liability and business risks. It offers some tax advantages and high flexibility, but no employment rights or social security. The contractor simply issues invoices and manages their own taxes and insurance. And this type of contract is also preferred by professionals and freelancers for administrative simplicity and potential tax benefits.
Yes. 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 So these four types of contract you may be familiar with, because it basically it's the same all over Europe. There are these four general types where when the parties can choose from, depending on the situation. And sometimes we are asked what is the best solution, and actually the answer is quite simple. That it really it's a lawyer's answer, but it really depends. It depends on the objectives. It depends on the parties. It depends on how long this relation is supposed to be. What is the scale of this cooperation? So there's no one clear answer. What is best? What is worst? It depends. It depends on circumstances, and it's always good to consult lawyers or accountants what would be the recommended option. Here is I think the most important slide of our presentation, which is the direct employment, which is the gist of our presentation, direct employment by a foreign company. Because sometimes, as I said, there's not that employment is the highest form of hiring people, but sometimes the parties are in a position where they cannot go for B2B contract. They cannot, because the employee will be dependent, and the B2B contract is only in the situation where we can talk about some independence. So B2B contractor must be able to prove or to show that he is independent in how he does it. So very often it refers to people of special professions, like could be lawyers, could be scientists, could be artists, could be programmers, coders. If you hire a programmer to write the code, he can do it independently because he doesn't need any supervision in simple cases. But sometimes there is a situation where, because all other options, which my colleague just explained, the contract for specific work or mandate agreement or B2B contract, are not available, we are left with the only solution, which is the traditional employment agreement. And this slide deals with this issue, that how to handle this. This is not so easy, and this is quite a complicated. It's not hugely complicated, but it requires a special approach. Whether we talk about, and it applies to all European countries, EU countries, but also to countries like UK or US. UK or US company must register itself in Poland with Polish tax office as a employer. This requires some applications. As an employer, they should receive This is being called tax identification number. The number of documents which must be submitted. The processes can be arranged within a week, and it ends with the number given to the foreign employer, and the foreign company can actually start preparation to sign a contract with the person residing in Poland. It could be Polish person, but it could be also foreigners who are based in Poland. We have cases where some British programmers come to Poland and they prefer to work from Poland for many reasons. These you can see. I don't want to go through these 5 bullets, but there's a whole process of arranging mandatory medical examination. There is health safety training, which also must be conducted. So the foreign company, and normally you have to rely either on lawyers or accountants who will be able to handle this process for you. Of course, the important point is signing the employment agreement, the employment contract, and always we have questions: what law should be chosen? And our answer is normally that according to Polish labor law, the parties can choose a foreign law if they prefer. Very often parties want to choose the English law or American or state of Delaware or state of Texas law. So the Polish law, the parties can choose a foreign law for the employment contract. However, it's important to mention that this choice cannot deprive the employee of the protections they are entitled to under Polish mandatory labor law. So all the rules about the working time, about breaks in working times, about holidays, about health and safety rules, about remuneration, of course. Yeah, but we have dozens of rules, hundreds of rules, even deductions. Very often we have differences. What amounts could be deducted from the salary? So rules about deductions, rules about penalties, or how to handle grievances, warnings. This is all. The short should be governed in essence by the Polish mandatory labor law, in a sense that it can be better or can be more liberal than the Polish rules. So if Polish law says that the employee is entitled to 26 days of paid leave, the parties can agree that it will be 30 days instead of 26. So signing an employment contract is an important element, and very often, if the parties choose English law, we still have to go through the process of adjusting the English employment contract to include Polish solutions and Polish regulations. So at the end of the day, the parties have actually some kind of combination of English-Polish employment contract, which unites both countries. The same would be with state of Delaware or any American laws, that we have to then try to marry together the two systems so that there are no contradictions. And of course, the last point is also important, because this solution is the direct employment is a good solution, but it is a bit awkward. Awkward because each month the employer has to calculate and pay social security contributions, and also has to pay advance for the income tax for the employee. So there has to be at least 3 money transfers from the headquarters, from the main company, from the foreign company, whether it's Germany, UK, or US. There has to be 3 bank transfers. It will be salary, it will be social insurance contributions on behalf of the employee, and also advance for the income tax. And this has to be calculated by the Polish person here. Then we are sending information to this to the headquarters, and they pay. So this is quite difficult to. It is possible to somehow automate the whole process, but it's not easy because these amounts are very often subject to changes, and also very often the salary is expressed in foreign currency, though, so there has to be recalculated into Polish zlotys, because of course, maybe I should stress this, because of course the social insurance contributions and income tax in Poland, even if the salary is being paid in pounds or in dollars, all these contributions in Poland has to be paid in Polish zlotys to Polish offices. So as you can see, this is not so easy doable, but it requires preparation, and it makes sense only if we talk about 1 or 2, 3 hires. If the foreign company has a plan to hire more people, it doesn't make sense to go for such an independent hire. It would be better to set up a local subsidiary and hire people through this subsidiary. Now, just to show you in contrast, this using a B2B contract, sometimes, not always, but it is possible that the companies have such a possibility to choose. Very often not, because this, as we say here, this can be and this solution is very common among IT professionals and freelancers. The administrative burden is much lighter, but as I said earlier, this arrangement is only suitable if the relationship is genuinely business to business and not an employment relationship, because it may cause serious problems. So very often we have questions from our client or potential clients, and we have to distinguish. We have to say what kind of relationship it is, what they are trying to forge among themselves.
Another solution, civil solution, is a contract for specific work, also known as project-based or fixed-term contract. The contractor agrees to deliver a specific result, for example, a design, software, or written article, and the client agrees to pay for it. This is a gist of contracts for specific work. And this type of contract offers, as I said previously, several compelling advantages for programmers, for IT specialists, making it an attractive and often optimal choice compared to traditional permanent employment. One of the key benefits is favorable tax arrangements. This contract that includes transfers of copyrights can be beneficial for IT professionals, because it allows to apply a favorable tax regime with lower taxes. This is possible if the employee transfers the economic copyright to their work to the employer under a contract that explicitly separates copyright remuneration from other salary components. And under such an agreement, the employee can apply a 50% tax deductible cost to the income received from transferring copyrights, which effectively reducing taxable income by half.
Yes, and now we have we were thinking while preparing for this webinar, we're thinking of a case which would be interesting and bracing enough just to show you the complexity of this legal arrangement. whether to go for employee relation arrangement or B2B arrangement. So we have a case which is taken from our experience, which we handled successfully. It's a U.S. corporate. Very often, U.S. corporations which operate in Europe, they operate through UK company. So when they hire people in Poland, they also do it through the intermediary of the UK company. And sometimes, especially in this preliminary phase, when they want to test the market, they decide to hire a person of relatively higher status, and it could be even the head of the whole European operation. So we talk about the person, and in our case was a person who is of really high status and very high in the hierarchy, and then to test the market and to see how the U.S. corporation can enter the European market through Poland, which is part of EU, of course. And then you can see in this example, you can see vividly that some of the options are, which my colleague mentioned earlier. So we presented to you 4 options. We have the going from the end. We have the mandate agreement. It's not applicable because that's not suitable. Contract for specific work requires always that there is a work which has to be produced. So it's like a computer program or a novel or a poem or whatever, something which has been created by the author. So mandate agreement not, contract for specific work not. B2B contract is in this case also excluded, because this person, of course, would be part of the UK corporation, and it would be absolutely impossible to argue that this person hired in Poland would be independent. This is like complete madness to argue that he is independent and he is like a freelancer helping them to test the market. So the only possibility then is to, out of the 4 options, is this direct employment, which is, as we say, which is doable. But then it's an interesting case, because very often, if we have U.S. corporations trying to hire in Poland, very often there is another solution which has been invented by the market, which is the employer of record, which so far was not so popular in Poland, but actually in every single case where we have U.S. corporations which are very active now in Poland, and they try to in various fields, especially in IT, employer of record, which is a situation which is not which is a solution which is not regulated by Polish law, and in practice it works quite well. I will maybe it's a few words of explanation. Employment of record is a common solution for international corporations to employ in given country, like in Poland, without setting up a legal entity. So employment of record, employer of record legally employs person on your behalf, let's say, and they handle all payroll, taxes, compliance, and HR administration. But your company, if you want to hire such person through employer of record, so your company directs the employee's daily work, but employer of record is the official employer in Poland. So officially, when the authorities look at it, they see a chain of agreements. It's let's say Jan Kowalski, typical Polish name, Jan Kowalski, is employed technically by employer of record, and then employer of record has an agreement like a kind of rental agreement for Jan Kowalski to the company, to your company, and then Jan Kowalski works in this company, but officially he's employed by the employer of record. So legally, the employer for tax and compliance purposes is employer of record. And actually, this case is, I think, is very good, and to show you the reality which we are facing now, that there will be more, and there will be more solutions like this coming to Polish market, because because it grows very quickly, and all international solutions are coming quickly to Poland. So basically, I don't want to go exactly how we finally resolve it, but I can tell you that the biggest distinction, or the biggest discussions which we had actually with clients, was whether we should go for the solution which is offered by this employer of record, which on the Polish market there are several very reputable companies like Deal. Maybe you come across the name the name Deal, and they offer this sort of solution. So the biggest dilemma for us was whether we should whether the client should finally go for the solution for this employment of record as a common solution for US companies, or to go for the a little awkward and a little not so comfortable solution with a direct employment. But as I said before, this is not that, and I can say again that the truth is that nothing in this world is black and white. So it is looking at this example, I can tell you again, this is not a very easy answer whether this should be, which of the option is better. In this particular case, it turned out that the client insists on confidentiality, and because the person who was supposed to be hired was supposed to have access to a lot of commercial information and business information of the US corporation. So in this case, so as you can see, there's this additional aspects which can play a vital role, because the employer of record, and maybe we should cover this in our webinar maybe next time, but employer of record is becoming now a very popular solution, but not always. That's why we in each case we have to analyze whether we should really stick to our 4 purely Polish solutions, so direct employment, B2B, mandate agreement, contract-specific work, or really whether employment of record or employer of record would be a viable solution. In this case, when we have a US corporation which insists on keeping confidentiality and trying to protect the business, the information, the business secrets, it would be extremely difficult to, if it comes to the court case against this Polish employee, would be extremely difficult, because as you can see from this example, there is no contractual relationship between US corporation or actually UK company acting on behalf of the US corporation. There's no contractual relationship between basically US business and this Polish employee. The only possibility to sue the Polish employee for the breach of confidentiality would be through the employer of record, which is very difficult and probably would not bring any positive results. So in this case, we finally agreed, and we decided with the client it would be much better to go for the direct employment. But there could be other cases where really the employer of record would be more suitable solution, basically easier to handle, because then all these obligations which I described during the direct employment would be taken by the employer of record. This is this was the last slide. Now it's we have 3 minutes for the Q&A session. We have I can see we have several questions.
The first question is remote work suitable and legally regulated for hiring employees in Poland under the direct employment scheme? So the question is, yes, remote work is suitable and legally regulated for hiring employees in Poland. Since April 2023, Polish labor law formally governs the remote work, defining it as work performed entirely or partially outside the employer's premises at a location agreed between employer and employee. It is often the employer's home. So employers and employees must agree on terms such as a place of work, ways to report tasks and working hours, and how work-related costs, for example, computers and internet and energy, are provided or reimbursed. This can be included in the employment contract or in a separate remote work agreement. Therefore, under direct employment in Poland, remote work is well-established, formalized options that companies can use to hire Polish employees without a local presence. So the employer assumes responsibility for complying with Polish labor, tax, and social security laws, including those specific to remote work arrangements.
Yes, so I can see I can see questions regarding employer of record. So the question is, are employer of record services legally viable in Poland? Thank you. And the second question, so I can answer these two questions. Is using employer of record safe in Poland? Thank you. Very interesting questions, and I can answer that in our view, and of course we may differ with other law firms, but in our view, employer of record services are legally viable and in Poland. But I would have to say that the legal status has some nuances. As I said earlier, this is the concept which is not specifically regulated under Polish law, and there could be some doubts because it's a loophole where they are trying to fill. Definitely, when we look at this employer of record services from the tax and compliance perspective, this is fine because they handle taxes, they handle all compliance issues, and they are very well prepared. I mentioned Deal. Deal is an American company from San Francisco, and they are very active in Poland. So if you go for the reputable employer of record provider, then it's safe. But there are these nuances that in terms of taxes and compliance, from the tax perspective and compliance perspective, this is fine. Absolutely, there's nothing to which negative can be said. But this is not all. Yes, so they cover the most important area, which payment of the contributions, compliance, training, everything. Yes. But when it comes to, as I mentioned earlier, with the confidentiality issues, even termination of employment or copyright, they could be employed. There could be also. I mentioned programmers, and Poland is foreign companies very often try to hire Polish programmers for IT specialists. So if you use employer of record for employer of record services to hire a programmer, then the contract with the employer of record services covers tax and compliance, but it does not cover copyright, because the copyright under Polish law, if you have an employee and the employee creates a work for the company, automatically the company becomes owner of this work. In this case, because technically the employee is employed by employer of record, there has to be an additional agreement which transfer the economic ownership of economic copyright from, actually we have the transfer from the employee to employer of record, and then from employer of record to the main company, to the US corporation. So there could be, so it works in some cases, sometimes better, sometimes worse, but very often you have to look at the whole, and I'm not very creative here, but I can say that you have to look at the whole area holistically and say what is important. And if confidentiality or if copyright is important for you, or if even termination rights, because there could be some termination clauses which are difficult. So at least the three criteria: confidentiality, very important and very, very hot topic, I would say now. So confidentiality, copyrights, and also termination rights. If your company insists or treats one of these three factors as an important point, then probably would be better to go for the Polish solutions, which is direct employment, and then have a direct contractual relationship with the employee. If, however, none of these points is so important, if you really want to have an employee, then you can try, and if you, as I said, if you there are a number of these service providers, but if you choose one of the reputable firms providing employment of record services, it should be fine. It should be safe. They have been on the market, I think, for the last. It was started just before COVID, so 2018, 19. So we have now about 6 years in practice. We've heard only positive feedback about these companies, but there are many small or untested firms, so you should be careful. We have many questions, but I'm afraid we now have 50 minutes past, so we will try to answer separately other questions. I would like to thank you, everybody who attended the webinar.
Thank you.
Thank you. And these questions are very valuable to us, because it shows it gives us indication what should be our topics, what you would like to talk us about. So thank you not only for attending the webinar, but also for the questions, which is so valuable feedback for us. Okay, thank you.
Thank you.